Indeed, it's a very good evening to all the League Champion. My name is Kim, and the content of this recorded material refers to the discussion of the course of action. When we are articulating from the legal grounds, the course of action basically refers to a technical legal concept which constitutes of the facts which gives rise to a very successful claim that is enforceable to the court. In this regard, each and every single case that is said to be submitted before the court is required to constitute a course of action in which a plaintiff is expected to prove the allegations drawn in that case that gives a green light to the court to rule over the matter. And it states out that the case submitted before the court did not constitute any of the course of action, then that case is declared to be invalid. Therefore, even attorneys cannot help you if the case presented before them did not contain any course of actions, and even the courts themselves, they will not even be in any good position to attend to your case provided that it lacks the course of actions. What basically the court will do will either order the dismissal of your claim and order you to pay the cost. We have actually different grounds that are referred to be course of action when it comes to divorce. For example, like in the case of Van Wyk versus Van Wyk and Sibonga versus Chaka, if you go through those cases that we have actually covered in the introduction to law, you will be able to be exposed to different grounds that are said to be the cause of action. For example, we have infidelity, for example, like that. That's a cause of action that will raise a very successful claim when it comes to divorce matters, or maybe lack of intimacies and so forth. These are examples actually of the cause of actions that will be able to be considered by the court when it comes to the ruling of divorce matters. But why do I need a cause of action in my case? There are actually certain public policy reasons on why people should have cause of actions in their cases. People are always suffering losses and injuries, in a sense that if we tend to allow each and every single person to sue the other, this will be the establishment of injustice. Therefore, the courts have to make sure that there should be a valid cause of action that will be successively within that matter for the courts themselves to rule over such matters and make fair judgment in regards to any case submitted before it and establish justice within the societies. When it comes to the course of action that declares an unconstitutionality of a certain law, in our legal system, the cause of action or the right of action arises in instances when a certain law is said to be unlawful, in which it is declared to be on the grounds of being on contravention with the provision stated in Chapter 3 of our Supreme Law, which states the fundamental human rights and freedom. If an enacted law is said to be in contraventions with the theme of the Bill of Rights, then it has to be declared unlawful. And in the case of Marbury versus Madison, this is an 1803 case. The Supreme Court actually establishes the rights of the court to determine the constitutionality of the actions of the other branches of the government. In this matter, actually, Chief Justice Johnny Marshall establishes the principles of judicial reviews, which is a very important legal addition, which is declared to be grounded on checks and balances. In accordance to Chief Justice John Marshall, jurisprudentiality propounded that if a law is repugnant to the Constitution, then it's declared to be void. And in this case, this was actually the first time in which a law was declared to be unconstitutional, which was said to be passed by the Congress and signed by the President. So this is actually raising the course of action to declare such a law unconstitutional. The course of action's defense in extinctive prescription. This basically emphasizes on the issue of applicable law that is said to be submitted, in which the tribunals are actually expected to address it and required to rule fairly on it. In most of the municipal law systems, the lapsing of time actually develops or influences the possibility of presenting cases to the court, provided that since the extinctive prescriptions is an issue of decisive and legal importance, and if a claim is said to be extinguished by the lapsing of time, such dispute is regarded to be finalized. Such dispute is regarded to be at the end, to be concluded.